Hello, everyone, and welcome to today's ACLU Leadership Forum on our Supreme Court case, U.S. v. Skrmetti, a landmark case for transgender justice and bodily autonomy. My name is JJ Straight. I use she, her pronouns, and I'm the National Campaigns Director for Reproductive Rights at the ACLU. Yesterday, the Supreme Court heard the ACLU's arguments alongside the U.S. state government on behalf of 3 transgender youth and their families to strike down Tennessee's ban on hormone therapy for transgender youth. The court's decision could have massive implications on the freedom of all people to decide what is right for their own body. This case will be a major test of whether the court is willing to stretch its devastating decision in Dobbs v. Jackson's Women's Health Organization, which is the case that overturned Roe v. Wade, and to threaten other healthcare like IVF and birth control. Following yesterday's arguments, we wanted to gather you all, our top supporters, to brief you on the case and reflect on how we can propel the transgender justice movement forward together, especially in light of the incoming administration. We are joined by 2 experts who have been very, very steeped in this case. I'm going to ask them both to turn on their cameras and wave hello. Chase Strangio is co-director of the ACLU's LGBTQ and HIV project. He appeared before the Supreme Court yesterday and is a nationally recognized expert on transgender rights. Chase has fought this disgusting wave of anti-transgender laws that have passed in state legislatures since 2016, including 12 legal challenges against state laws. Ria Tabacco Mar is the director of the ACLU Women's Rights Project, where she oversees the ACLU Women's Rights litigation. Previously, she was a senior staff attorney with the ACLU's LGBTQ and HIV project. Welcome back from the Supreme Court. I know you both have plenty to share, so we're going to jump right in. I did want to note that this is an off-the-record conversation. So if you're a journalist among us today, please understand that nothing that is said here is for attribution or citation. It's important for us to feel like this is an intimate forum and a safe space for all of you today to raise your questions. We have reserved time at the end today for questions, and you can use the Q&A button that's at the bottom of your screen, and we'll get to as many of them as we can. Now, I'd love to jump in and get started with you, Chase, and Ria, we'll bring you back in just a bit. Chase, you just argued before the Supreme Court. I want to hear, what was that experience like? But first, could you set the stage and provide some background on the case and tell us what's specifically at play in Tennessee?
Yes. So thank you all for joining. Thank you to JJ. Just so everyone knows, JJ was out in the cold for 100 hours yesterday, which I know that's more hours than are in a day. But I too am a little bit tired from our time in DC, but just very happy to be here with all of you. So this case, United States versus Skrmetti, in January of 2023, when the Tennessee state legislature came into session, the very first bill that was introduced, that was pre-filed, was Senate Bill 1. And that was the bill that was categorically banning evidence-based medical care for adolescents only when it is prescribed in order for someone to live inconsistent with their sex. So it uniquely targets the medication that transgender adolescents need, that they get through the consent of their parents and the recommendation of their doctors. And in January of 2023, I flew down to Nashville, testified against the bill. It moved very quickly through the state legislature and passed and was signed by the governor in March of 2023. The ACLU are partners at Lambda Legal, at ACLU of Tennessee, and at the law firm of Aiken Gump, filed a lawsuit very quickly after this bill was signed into law, because it was set to go into effect on July 1st, and we wanted to make sure that nobody lost access to their medical care. We represented 3 transgender adolescents, their parents, and then a doctor who provides this care in Tennessee. And we ended up, in the scheme of litigation, it's very quick to go from filing a case in March of 1 year to the Supreme Court in the winter of the next year. So that the last year and a half has been spent litigating this case along with other cases across the country, trying to ensure that transgender adolescents can access this medical care that they're relying on, that decades of clinical experience shows is critically necessary for many people. And unfortunately, in the appeals court, we had our injunction, which had blocked the law, overturned, which allowed this law to go into effect, and unfortunately set off a wave of bad court decisions that, as JJ alluded to at the top, were relying in large part on the Supreme Court's decision in Dobbs, which I will explain later. And we ended up in a landscape across the country where we have a catastrophic loss of healthcare for adolescents who need it. And in Tennessee, that means that our clients have had to travel out of state, driving and flying sometimes 10 hours each way in order to access the care that their parents consent to for them, that they rely on. And so this is a fight to ensure that people can continue to get the healthcare that they need, that parents can continue to care for their children, and that doctors can continue to take care of their patients.
Yeah. Well, I know for me that sometimes the legal cases can seem really complicated, especially for those of us who didn't join you all in law school and may be unfamiliar with all the legalese and jargon. But Chase, the root of this case is quite simple. Can you explain the core of the ACLU's argument?
Yeah, so it is quite simple, and it goes like this: the Equal Protection Clause protects any person to equality under the law. In essence, that's what it says, and we think that that includes transgender people. And this is a law that on its face says that you can get a medical treatment if it is consistent with your sex, but you cannot get that medical treatment if it's inconsistent with your sex. And we think that in the face of the statute, that is a very clear example of sex discrimination. You can get something, for example, if you have a birth sex of male and you're seeking testosterone in order to undergo a typical male puberty, but if you're assigned female at birth, you cannot get that very same treatment for that very same purpose. Under decades of precedent, we say that's a straightforward sex classification that is unconstitutional under the Equal Protection Clause. And just because we're talking about medical care that transgender people need doesn't mean that we contort the ways in which this court has understood sex discrimination for decades. And so we are asking the court to strike down this law as a violation of the equal protection rights of the transgender adolescents who rely on this care.
Well, and at the ACLU, we know very well that when one group's rights are threatened, all of our rights are threatened. So what are the far-ranging repercussions of this case should the court rule in favor of the state of Tennessee?
Yeah, so we're living in a scary time for transgender people, and so I want to acknowledge that at the top, and obviously in the wake of an election in which trans people figured very prominently in attack advertising, and with an incoming president who has threatened transgender people directly with things like expulsion from the military and national bans on healthcare for transgender adolescents, federal funding bans on healthcare for transgender individual adults who rely on any federally funded program, whether that's Medicaid, public employment through the federal government, TRICARE, many other forms of federal healthcare benefits. All of those restrictions on our healthcare are going to look in some way like the Tennessee law. They will ban healthcare because it is inconsistent with someone's sex. And so what the court is looking at in this case, challenging SB1, United States versus Skrmetti, is whether this kind of restriction on healthcare or ban on healthcare is a form of sex discrimination. And if the court rules that it is not, then that is going to embolden an already very emboldened set of lawmakers to further target trans people with fewer recourses in the courts. And as we know, the very point of the Constitution is to be a check on the majoritarian targeting of minority groups in this country. And so if the Supreme Court comes in and says, well, in this circumstance, this blatant form of distinctions based on sex in law is perfectly fine, and we can let lawmakers do as they wish, then I expect we will see very quickly further attacks at the national level on healthcare for transgender people. And that will be the most immediate effect of the court's decision. And of course, they're likely to do that regardless of what the court does. But the scary thing is that winning this case will be a critical tool to stop those efforts from the federal government, from other states. And so we are very much trying to help the country understand that we don't want a country where the Supreme Court can slowly chip away at all of the gains that we've made to ensure that constitutional guarantees can continue to be enforced against disfavored minority groups. And that's really what is at risk here.
Yeah, absolutely. And I'm sure this group knows this and has heard it before, but every person and every circumstance is different. And we obviously all deserve the freedom to control our bodies and to seek the healthcare we need. Chase, zooming out, can you set this case into more context for us? I know we've said it before, and it's always startling when I talk about this number, but in just the last 3 years, 24 states have banned hormone therapy for transgender youth with gender dysphoria. Can you walk us through the landscape a bit and talk about how did we get here?
Yeah, so this is something that just absolutely troubles me and devastates me so much. And I'll talk about this most recent wave of laws targeting transgender people and our medical care. But to sort of understand how we got here, we have to go back about a decade. And in 2015, the Supreme Court struck down bans on marriage equality and fighting to uh, ban gay people from marriage and to criminalize same-sex intimacy in a variety of forms really was the centerpiece of a significant part of the Christian right movement in the United States. And when they lost that fight in 2015, they were ready to pivot to targeting other members of the LGBTQ community. And they swiftly turned directly to trans people. And we saw in November of 2015 in Houston, Texas, there was this fight at the ballot over an equal rights ordinance that would have added non-discrimination protections to many different groups of people in Houston. And the people protested that passage of that ordinance and ended up getting a repeal measure on the ballot in Houston. And though that ordinance would have protected 15 classes of people, including disabled people, people of color, immigrants, veterans, it also would have included protections for trans people. And the very well-resourced organizations that had fought against marriage equality for decades started to pour into Houston to build this narrative campaign demonizing trans people. And ultimately, the ordinance in Houston was repealed based on an anti-trans campaign. And what that taught our opponents is that targeting trans people can be, but not always, an effective political strategy. And it certainly was in November of 2015. And what came next, as many people probably remember, in the beginning of 2016, were the first wave of anti-trans bathroom bills. And that wave resulted in a series of high-profile vetoes from Republican governors, including former Governor Dugard in South Dakota, because it sort of came out of nowhere for some people with this fixation on trans people. And at the time, what Governor Dugard said when the anti-trans bathroom bill was introduced in South Dakota in 2016 was, well, it sounds like a good idea to me, but I've never met a trans person. So the ACLU and our partners got trans people to meet with the governor. He was very taken with the harms that would have flowed from that bill, and he vetoed it. which was a turning point in 2016. And then later in that same legislative session, folks might probably remember HB2, which was North Carolina's infamous bathroom ban. And it was rushed through a special session in North Carolina. Within 24 hours, it was signed by then Governor McCrory. And again, there we had a very swift backlash supporting trans people. Businesses pulled out of the state of North Carolina. In 2016, when you had overwhelming Republican success at the polls, Governor McCrory lost his race, in large part, people thought, because of his support for HB2, and that's when Roy Cooper became the governor. And from that period, we started to see a little bit of waning from the momentum that had been built in that fight in Houston on the attacks on trans people. And in part, that was because Donald Trump was president, so there wasn't as much momentum in the states. But ultimately, what happened over time is our opponents regrouped and started to target trans people both in the public rhetoric and public forums and in state legislatures. And they moved from restrooms to sports. And in 2019, attacks on trans girls in sports became an opening to start to really galvanize this demonization of trans people in our bodies. And from 2019, when we saw those first sports bills, and a lot of people were pushing them and supporting them, claiming, we don't have a problem with trans people, we're just worried about sports. And it very swiftly turned from 2019 to a conversation about sports to 2021, where we saw the first and only medical care ban to pass in the United States over the veto of then Governor Asa Hutchinson in Arkansas. And from 2021 to 2024, we now have 24 states in this country that ban this healthcare for trans adolescents. In a period of 3 years, the map has changed so catastrophically, and that is where we find ourselves today.
Yeah, incredibly massive change in such a short amount of time. Thanks for breaking that down for us, Chase. I didn't think through all the background to Houston. That was really helpful context. Ria, I'd love to bring you in and hear from you. You were in the courtroom yesterday and have also been working behind the scenes on this case. As you know well, the court's decision could have these ripple effects across our freedoms, particularly women's rights and reproductive health, which are already being stripped away, as we know, across states. What are the parallels you are seeing with reproductive freedom?
I'm so glad you asked this question, JJ, because all too often it's our opponents who are drawing the lines between attacks on abortion and attacks on gender-affirming healthcare. And our side, as Chase described, has really been playing catch up. And that was, I think, painfully apparent in the Supreme Court yesterday, where we saw, Justice Samuel Alito, who of course was the author of the Dobbs decision overturning Roe versus Wade, cite his own opinion in Dobbs, essentially in support of Tennessee's position that its ban on hormone therapy for trans adolescents is constitutional. And his theory goes something like this. So let's turn back the clock. Chase did a little deep dive into history, so I want to bring us back to 1974, in which point the Supreme Court considered a case involving California's disability insurance scheme, which disallowed disability claims for pregnancy. And the question that got to the Supreme Court was this exclusion for pregnancy a form of sex discrimination? And I think if I asked each of you on this call who don't already know how this case turns out, or spoiler alert, I think we all know, because we know it wasn't good because I'm telling you about it now. Right, we all would say, of course, exclusion of pregnancy claims is a form of sex discrimination. But in a sleight of hand, the Supreme Court essentially said, no, because if we think about the world of pregnant people and non-pregnant people, there are women in both groups. Okay, that's a little bit of word salad right there. Fast forward to 2022, and most people thought that the 1974 decision had long been discredited. It was no longer good law. The law had evolved. We had begun to recognize that discrimination based on pregnancy so often involves sex-based stereotypes about, the respective roles of women and men as caregivers and as breadwinners. Then came the Dobbs decision, and in the Dobbs decision, Justice Alito invoked the court's 1974 opinion as support for the idea that just like discrimination based on pregnancy, bans on abortion were somehow not discriminatory. Essentially, in Alito's words, Because they affected only women. So first we had women in both the pregnant and non-women pregnant group. Now we have only women. Somehow both of these situations we find no sex discrimination. And that has become the most powerful tool in our opponent's arsenal to challenging bans on gender affirming healthcare for trans kids, because it's all a sleight of hand, where they essentially say, hey, we're discriminating against both transgender boys and transgender girls. Somehow this erases the discrimination, even though if you think about it from the perspective of our clients, take Ryan Rowe, right? Ryan is a boy who seeks hormone therapy to masculinize his appearance. If Ryan were assigned male at birth, he would be able to access that treatment. But because he was assigned female, he's not. And it's no answer to Ryan to say that some hypothetical Jane Doe would also be denied the same treatment because of her sex.
Yeah. Well, it's clear that our opponents are trying to control our bodies and thus our lives and our families from all directions. But we know the ACLU is here to fight back from all angles. And so we're going to dig a little bit into our work outside the court in a little bit, but I'm curious to hear what it's like to be at the Supreme Court, Chase. You've been part of Supreme Court cases before, but this was your first time delivering oral arguments. What was that like? And what kind of questions did you field?
Yeah, so obviously it's a somewhat surreal experience, and it's particularly surreal to have your first oral argument be in a case of this import, and then of course in a case of this import on your own personal life and community. And in all of the media I was doing in the lead up to the argument, reporters would be like, "Oh, this is a big one for your first one. No pressure." So you know, I was preparing for weeks, as Ria knows. Preparing for a Supreme Court argument is such a team effort, where you are anticipating every possible question and coming up with the best answers. So ideally, by the time you get to court, there's no answer that comes that you haven't anticipated collectively with your colleagues and thought through what the best answer might be. Now, of course, in the moment, it's phrased slightly differently. You're having to assess the tenor of the argument. You don't want to concede anything. You also want to make sure to be responsive, but get to where you want to go. So there's just a lot of different factors at play. And of course, you don't have a lot of time. So you're basically distilling like 1,000 hours of preparation and your well-being and the well-being of everyone you care about into 15 minutes. No small task, to be sure. But you know, as anticipated in terms of the levels of preparation at the ACLU, nothing was asked that we didn't anticipate. So we prepared, we were ready, and much of the argument, what I think is interesting is that the central argument was about what we've been talking about. This is a sex classification in the law. It says you can't do something if it's inconsistent with your sex. It is very hard to deny that. And so a lot of the argument avoided that on some level, because even the justices, who I think are very inclined to rule against us, would have a hard time even asking a question that doesn't run them right into the problem that a law that is prohibiting something inconsistent with sex is about sex. So instead, they really focused on all of these things they've been hearing in the world, or things that the other side tried to put into the record about this care, and sort of suggesting that this care is uniquely harmful, which the district court absolutely made findings that it is not. Tried to suggest that these are not well thought out decisions, when we know that isn't true. We know that they've tried to suggest that, you know, this should just be left to the democratic process. So, you know, constitutional protections be damned, just go forth and fight for your rights with the legislative branches. Well, the whole point of the Equal Protection Clause is to protect the individuals who are excluded by virtue of the fact of systemic discrimination in representative government, to have a place to go for protection. And Justice Jackson really did focus extensively in yesterday's argument on this precise point, which is, if this court is accepting this idea that we just, you know, sort of throw up our hands, even when the government uses these types of classifications that we have said are suspect under the legal doctrine for decades, and says, well, go advocate with your lawmakers, that is a huge departure from what the Constitution is supposed to mean. And as Justice Sotomayor said at some point in the argument yesterday, when she was questioning the Solicitor General of Tennessee, and he was saying, well, transgender adults, because at that point it had shifted to whether the arguments would be the same if it was a ban for adults. He said adults could just go advocate with their representatives if their healthcare was banned. And Justice Sotomayor said, well, it's pretty hard to do if you're less than 1% of the population.
Yeah, that's a clip I have heard over and over today. Pretty clear what the justice was saying there. I mean, you just talked about the incredible preparation that went into preparing for the oral arguments yesterday. And that sounds like you really knew the questions that were likely to come. Was there anything that surprised either of you during yesterday's arguments?
Well, I'll go first. I think, in some sense, the biggest surprise was the lack of surprises. So despite our preparation, your worst fear is always that you're going to get a question out of left field that the team hasn't considered, and that you're going to put, your oralist who you've sent up on behalf of a whole group of people to field something in the first instance, and that didn't happen. And I think that really was a testament to our preparation. I guess two other small things I'll note, as I think virtually all of the news coverage has highlighted, and folks in this call probably know, Justice Neil Gorsuch was silent throughout the arguments, which lasted 2.5 hours. This is very atypical behavior for Justice Gorsuch. He's typically a very active questioner, and he was very active in questioning in Bostock versus Cleveland County, the 2020 case in which the Supreme Court ruled that it's illegal to fire someone for being trans, a case in which the ACLU was counsel, and Chase and I were both involved in the preparation for oral argument. So what a difference being in the court 5 years ago for oral arguments in Bostock versus today. We heard nothing from Neil Gorsuch, and he clearly had made a calculated decision not to tip his hand. I think news organizations seem to have assumed that means he's inclined to rule against us. I think I don't necessarily have the same takeaway, so folks are looking for a shred of hope. I don't necessarily assume that's the case. The logic of Justice Gorsuch's 2020 opinion applies equally in this context, and I think he definitely sees it. The one other moment I just want to highlight for our supporters is something I thought was really special, which was, the one off-the-cuff moment I would say was when Chase was actually able to make a joke with the justices, and it was really a remarkable moment in the courtroom because you could see the justices' faces light up. They were so warm and they were so reactive, and it was a real moment, I think, of the justices saying to Chase, like, you're one of us, right? You're in our club. And one of the many, many things that was significant about Chase presenting this argument was, of course, to show the Supreme Court that trans lawyers are just like them and are part of all of the spaces in which Americans travel, including the extremely exclusive Supreme Court bar. And so I thought that was just a particularly deft touch on Chase's part, and the justices responded really well to it.
Yeah, so I think I will share with Ria. I share with Ria that, and as almost every person who has commented, that the biggest surprise was Justice Gorsuch's silence. It is a surprising thing in general for a justice. I know in the past we've heard that Justice Thomas didn't ask questions, and he didn't for many years. In the new format, he also is engaged. There are almost no cases where a justice has no questions for either side, especially because the new format post-COVID is this seriatim at the end where the chief walks through each justice and asks them if they have any questions. And so this was very clearly a decision on Justice Gorsuch's part. So we just don't know what that means. And also, many justices, for example, Justice Barrett, is always someone who doesn't necessarily show her hand in oral argument. She asks very incisive questions of both sides. You don't always know where she's going to come out. So all around, it was that was a big surprise for everyone coming out of argument yesterday. And I guess the other thing is more of an observation. It's not necessarily a surprise, but in 2019, when we were in court for the arguments in Bostock, we obviously had some of the liberal justices with us, but they were not impassioned in their defense of trans people. It was awkward at times, and certainly it was, I had a moment coming out of Bostock being like, are we going to lose 9-0 against us? Just because you didn't get a sense that people really were feeling the argument deeply. Now, a lot's changed on the court since 2019, and the dynamics have changed quite significantly. But Justices Jackson, Sotomayor, and Kagan were making impassioned defenses of the Constitution very clearly, and also of the the real people at the center of this case. And Justice Sotomayor in particular was really drawing on the facts in this case, talking about the harms to our clients, to the individuals whose healthcare was taken away, in a way that was very moving for anyone who was listening.
Yeah, I haven't been able to hear all of it, but I found that very heartwarming as well when the pieces that I heard. Well, I'm going to ask the impossible question, Chase, which is we don't expect to know the court's decision until probably next June. But do you have any predictions based on their questions?
I don't, it was always going to be an uphill battle. Because we are in a moment where it is difficult to win constitutional protections for disfavored groups, both in the federal courts and particularly in the Supreme Court. But I have, though not an optimistic person generally, though I try to be, have remained optimistic here because we are asking a very straightforward question. This is a statute that on its face says you can't do something inconsistent with your sex. And the Tennessee legislature put into the statute that one of the reasons why this medical care is categorically banned is because Tennessee wants adolescents to appreciate their sex and doesn't want adolescents to be disdainful of their sex. And that is why when the Solicitor General of Tennessee got up there, he could literally not make a coherent argument about this being sex neutral. I still am going to hold on hope that there are 5 justices who agree that this is sex-based. Now, that doesn't mean we necessarily win. They could rule that this is because of sex and then say it still survives the requisite standard of constitutional scrutiny. But just getting them to recognize it as a sex classification would be a huge win for us. And so I'm going to hold on hope that there are 5 justices for that. Now, anyone who's following the post-argument reporting is not, reading the tea leaves in a very optimistic light. I think that is often the case coming out of civil rights cases at this court, where people do generally predict a 6-3 split. And there is reason to believe that is how it will end up. But it's a long way until June, and that's usually when these cases are decided. And so we did our part, and now we wait. And I continue to think our arguments are right and clear, and hopefully they won't distort their constitutional doctrine just to avoid protecting trans people.
Yes, let's hope that they follow that. Well, you all mentioned that I was outside the court yesterday. So we're going to move outside a little bit. Yesterday, we had the most incredible showing I have ever seen in front of the Supreme Court. You both mentioned it was 20 degrees. It's December after a late Thanksgiving, and yet 1,000 people. And I think that's even a conservative estimate as an organizer from all over the country joined the ACLU and Lambda Legal yesterday in solidarity with trans youth and their families to stand definitively against cruel and discriminatory healthcare bans and for our, against our shared freedoms. We set out to deliver a clear message to the Supreme Court that law, science, and the court of public opinion are absolutely on our side. And I have to tell you, boy, did we demonstrate that yesterday. Chase, what did it mean for you to see so many people supporting you and our clients? When you walked out, what did that look like, and what did that experience mean to you?
Well, first, just huge thank you to JJ for the absolutely incredible effort getting people out in these cold conditions. And really it was so beautiful. And I've only been inside the Supreme Court twice for arguments, and that was in 2019 for Bostock, and then yesterday. And there is something so incredibly powerful about coming out to a rally outside. It is an amazing, energetic experience, and in this case, it was such a massive rally with music and joy, and so many young people and the parents who love them. And when you look at pictures from yesterday, and you look at these kids just being kids and celebrating who they are, I don't understand how you can want anything other than the best for them. And one of the things that, so I'll say just two things. How did it feel? It felt so beautiful and so amazing. And it reminded me that no matter what happens with this case, we have a movement that will continue to grow. People who have struggled in the darkness internally and recognized who they are and done that self-reflection to come out into the world and declare that and defend that will not go back. It is simply that forward progress does not dissipate, so we will continue that. And then the other thing I'll say, and I hope that this is something that we continue to build in this country, is some amount of love and compassion for each other, because these are families who love their children. These are kids who want to be kids. These are doctors who want to do right by their patients, and their decisions for their families and for themselves harm literally no one else. And not only do they not harm anyone else, they don't affect anyone else. And so the amount of energy that other people are putting on the lives of people who are just working through what they need to work through is, I think, frankly, ridiculous. And when you see people just being themselves in a space where they can be, it is so liberating and so beautiful. And that's what I felt.
Yeah, I couldn't agree more. I got to be out there and watch it build, and really, I have to say, you all, it was cold, but it was also a party. I mean, it really was like a real moment of intense community in the most positive way. Ria, what was the rally like from your perspective, and why do you think it's so important that we were out there?
You know, we often talk about organizing as if what happens in the court and what happens outside of the court are happening on two separate tracks. And the truth is they are so closely intertwined. I mean, Chase talked about the difference in the questioning from the justices. And I really just want to underscore, right? It wasn't just the justices who were with us who had changed the way they talk about transgender people. All 9 justices, well, 8, we didn't hear from Justice Gorsuch, but all 8 justices who asked questions have dramatically shifted how they talk about transgender people, their comfort talking about transgender people. That was a huge shift. And some of that, of course, is what we did in our briefs and in the many friend of the court briefs that folks submitted for us. But a lot of that was because the public narrative has changed. And part of that is through things like rallies, where we give the justices, the justices are also members of the public. They are also seeing our clients and these families in the news. They are also reading about what it's like to be a parent of a trans teen. Many of the justices are parents themselves, right? And so all of that work goes into how the mindset that justices are in when they're approaching the case. I mean, even Justice Alito used the phrase assigned sex at birth in the courtroom. And I think there was, if we had not been instructed many times to be silent or we would be arrested, I think there would have been a collective gasp in the room when Justice Alito said that, because it really would have been unthinkable 5 years ago. And so much of that is just a testament to the power of organizing and the power of public education to shift the narrative. And that absolutely impacts how receptive the court is going to be to our arguments in court as well.
Yeah, I think that people do tend to kind of think of like just what's going on inside the court. But I really want to underscore everything you just said, and also just say, like, I have been an organizer a long time. And I was worried because we had a lot of things that were going to be a challenge yesterday. The weather, the time of year, as we mentioned, the election, and sort of a sense of like, is it worth it? And what are we doing? And, a fear of coming together. And I was wrong to worry about it. And that is because what we saw yesterday was truly a cross-section of organizations and supporters coming together, a huge real movement moment, I like to call it. And what it showed, I think, is that this is what people want to do. They want to build community, they want to be there, and that when we come together, we are a force. And we are a force that sends a clear message about the country we expect to live in and that we're going to fight to live in, regardless of this Supreme Court and, regardless of the moment we're in. We know that when we stand together and make sure that people are very clear about the fact that what we have is power in numbers, And we certainly showed that. I have to say, in my mind, I had this goal, you all, when I walked up, and I'm like, we have to shut down the street. We have to shut down the street. As an organizer, it's a huge thing for the Capitol Police. They do not want to do it. They resist doing it. And I wanted us to be so big that they would have to do it. And certain enough, right as we were just about to kick off, we were already so large that they had to shut down the street in front of the Supreme Court. And we kept growing and kept growing through the day. And it was so amazing. And I know that folks who are on here today want to know, continue to know what we can do. And the way that we built this was really through our people power at the ACLU action. I think Makiba is going to drop something in the chat. We're going to continue to push back in this moment and use this collectivity to make sure that we are sending these clear message, and that the power we have is our numbers and our passion. And anytime I'm asked, are you sure it matters? Every time I do, what about when I do this petition? JJ, how many more times are you going to ask me to do this? And I'm going to ask you every time until we win. And then I'm going to ask you for the next thing until we win, because that's how we do, that's how we make change, is doing these things. I am going to read this out too, but I know that Makiba is going to put it in the chat because it's quite long. But when you go to the ACLU page, you can go to our action.aclu.org and then /send-message /protect-trans-care-now. Honestly, if you just go to our ACLU website and search for Protect Trans Care, you'll also get there. Appreciate that. I really want to take us now to Q&A from all of you who've been listening to us. I will say we did receive a flood of pre-submitted questions from you all. And also, as Makiba mentioned at the top, please put your questions in the Q&A function. Everyone, feel free to use that Q&A function to ask questions now live. We have, a little bit of time left, but there may be questions we can't get to today. So we'll do our best to answer as many of them as we possibly can. If we don't get to some, we'll be sure to follow up after the event. I just want to reiterate again, as I said at the top, for any journalist on the call, that nothing that is said here is for attribution or citation. Makiba, would you please share with us the first batch of questions?
Yes. So our first question is from Sarah. The case was brought on gender discrimination rather than privacy. Could you talk about why? Another question we received is from Elizabeth. Did you consider adding a challenge based on parental rights to make medical decisions for their children? And the final question for this batch, do you believe that any challenges can or will be brought forth against states with shield laws?
So I can start here, and the first two are sort of connected, and the second one is maybe the easiest to answer, which is we did bring a parental rights claim on behalf of the parent plaintiffs. So and that claim is under the substantive component of the due process clause. The court has recognized certain fundamental rights. One of them, the oldest, as some cases say, of those rights is the right of parents to direct the care, custody, and control of their minor children. And this has included in the court's cases decisions over medical care for one's minor children. And that is instinctive to many parents, because we are, in fact, we not only have a right to do that, we are expected to do that. It is parents who are expected to make our medical decisions for our children. And sometimes those medical decisions are not always clear, because pediatric medicine is often full of uncertainty, and that is the role of parents. So we did bring a parental rights claim. We also were successful in the first lowest court on that claim. We lost that claim in the Court of Appeals, and then we asked the Supreme Court to take that. They did not decide to review that claim. So the only question before the court was the equal protection claim. So it's not that it was not brought, it just wasn't before the court at this time. Relatedly, there's also a privacy. The substantive part of the due process clause has a right to privacy. That has been significantly abrogated under Dobbs in terms of where do we go from here? And we have also not brought as many sort of affirmative rights to access healthcare for transgender people under the due process clause, because the statutes banning care for trans people say so clearly that they are sex based on their face, that they have always been understood as straightforward sex discrimination, that it was not really a novel proposition, is one of the many reasons why I was so surprised that these laws ultimately were passed and passed so aggressively around the country. I thought them to be so patently unconstitutional. And so it was a real simple, straightforward equal protection claim. And then, of course, we did bring the claim on behalf of parents. Then in terms of the SHIELD laws, those are laws that other states have passed to, in varying degrees, try to protect care for individuals whose care is banned elsewhere. And I think that it will be more difficult potentially for someone to have standing to challenge one of those laws. So, who will be injured? The most likely scenario would be a parent who doesn't support their child, trying to bring some sort of claim against an effort by a state to protect a child and an affirming parent. Those already exist in different permutations. I think we will see new attacks on trans people, including on states that are trying to be more protective of their trans residents and their families of transgender children. And of course, we will continue to try to robustly defend trans people in all of these contexts. Ria, did I miss anything?
No, I think you covered it, and I know we have a lot of questions, so let's leave time to get to some more.
Makiba, did you have our next?
Yes, so we received a few questions about bodily autonomy and a couple of specific questions around LGBTQ rights. These were pre-submitted questions. Charles and Robert both expressed concern about the attacks on bodily autonomy. If Dobbs is any indication of the courts interfering in bodily autonomy, how can we prepare for the court further removing protections for women and trans people? Are there other legal recourses we can turn to for shelter? Next, Malcolm and Ruthann brought up Congress transgender bathroom ban. Transgender constituents and staff have used restrooms of their choice for years without incident. What laws protect choice in using restrooms? And then finally, from Jane and Philip, both shared concerns about the future of marriage equality. How likely is it that the Supreme Court will overturn Obergefell?
I'm happy to go first and give Chase a break, and maybe I'll take the last question first, just because it's most recent in my mind, the question about Obergefell. So, the short answer is I don't think it's likely, but I do think we will see the court significantly erode the protections of what it means to be married, and particularly what it means to be married for same-sex couples. So just to take a step back, why Jane and Philip might be asking this question, I am certain they remember that in the court's 2022 decision in Dobbs, Justice Clarence Thomas wrote a separate opinion in which he said, not only do I think there is no right to abortion under, our Constitution's protections for privacy, but I also think that whole notion of sort of individual liberty to make certain intimate decisions about one's family and one's body has no basis in the Constitution. And then he listed a number of cases that had been decided under that theory. Obergefell certainly got the most news mentions. He also mentioned Griswold versus Connecticut, the case protecting the right to contraception. And in some ways, most troubling to me, Moore versus City of East Cleveland, a case about whether multi-generational families have the right to live together, or whether states and localities can actually ban grandparents from living with their grandchildren. So that is all on the chopping block. And I think each of those are different pieces of what we think of as reproductive justice, right? The right to not have the children we don't want, the right to have the children we do want, and the right to parent the children that we have in safe conditions. All of that is on the chopping block. That said, support for Obergefell is incredibly strong at this point, and we know that the court doesn't like to step too far away from public opinion, so it will break sometimes, but typically it prefers to follow trends, and it also doesn't have to overturn Obergefell outright to significantly erode what it means. So we've already seen the court, for example, allow vendors and service providers who want to refuse to work with same-sex couples in the wedding and adoption context to refuse to work with us. And I think it's more likely that we'll see that sort of erosion that undermines the idea that our marriages are on our equal footing with everyone else's marriages. Just on the first question, which I'm now scrolling back, in terms of other legal recourses, you know, in this moment, I think we've seen a huge energy towards state courts and state constitutions as a source of protection for women and for all of us in terms of bodily autonomy, both existing protections under state law and state constitutions, and also adding new protections to our state constitutions with 10 abortion-related ballot initiatives you know, up for election this November. So I think all that is tremendously energizing. I do want to note, of course, that, you know, depending on how the Supreme Court decides our case, it could pave the way for action at the congressional level, which could threaten our ability to work in state courts. But in this moment, I think we still have other avenues of recourse. We are using the avenues we have. We are creating new avenues for ourselves to bring new challenges. And all of that has been incredibly successful, and does also show the court that what they have done in Dobbs is incredibly unpopular, which I do think they care about, all signs to the contrary, because everyone just wants to be liked. And that actually includes Justice Alito too.
And I can address the really cruel efforts in Congress to ban transgender people from using the restrooms that were specifically targeted at Representative-elect Sarah McBride, the first openly transgender member of Congress. And what we're so I think first and foremost, this is just such an example of base cruelty that is coming out in the context of these bans, because nobody was really concerned about Sarah McBride using the bathroom. I think that that's very obvious. I don't think Representative Mace had thought twice about it. It was just in this rhetorical moment in which it seemed like there was an opportunity to capitalize on this. They really went in and attacked her. Now, obviously, the consequence of that is not only is Sarah McBride being targeted, it sends a message to other people who may want to run for public office that it is a very, who are trans, this is not going to be a fun, easy, safe thing to do. It's not that you can just go and do your job. And I think that is a very chilling, that sends a chilling message to people who are thinking about getting into politics. And if you look at what happened to Representative Zephyr in Montana, who was also an openly trans member of a state legislative body, similarly attacked, that this obviously deters people from engaging in running for office. And then, of course, what it also means is that people are less likely to be able to engage in the political process because they can't go to Congress because they can't go to the bathroom, so they can't lobby their Congress members. So all of this strikes me as, particularly ironic, since one of the parts of the argument that came up yesterday was about whether or not transgender people have political power, which for some reason our opponents continue to think that transgender people wield this wild amount of political power, despite literally every sign to the contrary. And so with respect to the question, what can we do about this? Obviously, one of the central ways in which people are protected in the context of something like Congress banning you from the bathroom is through the Constitution, because these are government actors who are acting to exclude you from places because you are trans, because of your sex, because of likely how you appear to others. Because we know that when people try to exclude people from the restroom based on what they think is an idea of their assigned sex at birth, what usually happens is they police people out of bathrooms based on how they look. So it is a fundamental entrenchment of sex stereotyping across the board and surveillance of our peers. And so we are going to obviously monitor all the ways in which federal buildings and federal programs are trying to exclude trans people, including by making it more difficult for us to use bathrooms in federal buildings. Because Representative Mace and Marjorie Taylor Greene have suggested that they're going to introduce bills to ban trans people from all restrooms in public buildings and federal buildings.
It looks like we're down to our last question. Makiba, did you want to throw that out?
Yes, one last question. Eileen asks, what action can I take locally?
I can jump in here unless one of you wants to.
Go for it, JJ.
All right. Well, this is my favorite question because what we really do need to do is, and I love the locality of it too, like we just need to stay engaged and keep calling our representatives and remain really vocal. It can be really intimidating or can feel like that doesn't matter sometimes if you're just an individual. And you may not be totally comfortable about how to talk about transgender issues, but you shouldn't worry about using the wrong terms and having all the right exact legal context. what you should be able to clearly put across is when you see injustice at the heart of this, it is so important to speak up. And I always say, I put my congressperson, both at the national level and at the state level, in my favorites. And that way I can call them when I need to, anytime that I need to, because they need to hear from me. They do work for us ultimately. And we know that a lot of times they are working directly against the interests that they need to hear from us. So thank you for that question. And as we are wrapping up today, I really want to thank you all. There are actions we can take together. We saw it yesterday, and we've been asked, and I wanted to note that we have some business leaders joining us today. We know you're tuning in, and we have a very specific call to action for you. While the Supreme Court is not elected, we know that, and as Ria was saying, they can be swayed by a changing culture and public opinion. And businesses that are promoting trans-inclusive messaging in the coming months will be absolutely critical. In fact, the more surround sound messaging we have, the harder it will be for this new Congress to advance its anti-trans policies and exclusionary funding. If you're interested in learning more about how your business can support the ACLU, please email leadershipforum@aclu.org. We just put that in the chat. Again, that's leadershipforum@aclu.org. That is a way that you can find out to learn how your business can support the ACLU and support this incredible work. You know, coming off of yesterday, it's just so incredible to be in another space to be able to talk about it. And so I am just so grateful for everyone who joined us today. I'm so grateful and absolutely honored to work with folks like Chase and Ria. Thank you for being with us today and sharing your insights, giving us those behind the scenes look at this case, what happened in the courtroom, and sharing how we can all stay in this fight for the long haul. It's been so great to be a part of this today and to continue to discuss the critical role that the ACLU plays, our collective part in protecting and advancing rights for transgender community, for our bodily autonomy, and beyond. You know, we know that there's no doubt that we have a lot of work ahead of us, but gatherings like this remind me of the incredible community we have fueling this work. I know a lot of you have a lot of different things that you could be doing right now, and instead you're here with us to hear about this and hear about how you can be involved. And that's because the ACLU community is truly unmatched. All of you, alongside our incredible staff of lawyers, folks like me who are organizers, and our core volunteers and supporters and activists on the ground, just prove without a doubt that what we have is strength in numbers, what we have is our perseverance, and what we have is the will of the people on our side. Today, if for some reason we weren't able to answer your question, you can email us again at that leadershipforum@aclu.org and let us know if we can answer anything else for you. Again, it was wonderful to be with you today. Thank you.